Amiot, the Secretary of State.
Yes, Ron. Brian Finn, on behalf of Charles Amiot, for purposes of an appeal from the final determination of the Secretary of State.
Okay, I've had a chance to review your motion and the supporting documentation. Go ahead with any argument you wish to make.
Your Honor, I rely mostly on my written statement. I would indicate that the hearing officer, the court's aware of Mr. Amiot's record. It's been attached as an exhibit, as well as the transcript from the hearing that was conducted on January 21st, 2025 in front of hearing officer Mayfield. It is our opinion that in looking at the rules, specifically Administrative Rule 13, I believe Mr. Amiot has demonstrated both an ability to abide by the laws of the state of Michigan. He has had an interlock device in his car for an extended period of time. He's also completed this course drug treatment court. He provided a substance abuse assessment that shows that he has a good prognosis, that he has a low likelihood of returning to any kind of alcohol or drug use. And I believe the third or the final step is the threat of recidivism. I believe that that's been mitigated not only by Mr. Amiot's continued sobriety and embracing of the sobriety system, the 12-step program, but by his adherence to the ignition interlock strictures and showing that he can comply in that way. I think this court has I'm not saying unfettered discretion, but it does have discretion to either put Mr. Amiot back on a restricted license, which I think serves no real purpose because he's already demonstrated that he can drive with an interlock device in his car with no issues. The court can grant full licensure. We're asking for the latter rather than the former. I see no point in putting Mr. Appellant back on a restricted license when he's already demonstrated by years of driving that he can drive and have no issues. I don't believe that he presents any future risk of alcohol-related driving offenses or alcohol consumption based on his testified to and his substance abuse recommendation. I'd ask the court to favorably consider overruling the decision of hearing officer Mayfield in this case and granting Mr. Amiot full driving privileges, as through the monitoring would be redundant and somewhat unnecessary.
I thank you. Ms. Goodrich, the Secretary's position.
Your Honor, on behalf of the Secretary of State, the defendant has 5 prior OWIs. One of the concerns was the substance abuse evaluation provided did not address the marijuana, despite his honesty in using that from 1972 to 2017. It would be unclear if any of the OWIs involved marijuana because the lab tends to stop testing after the alcohol level meets the legal criteria. So that was a concern. Secondly, there was a discrepancy between the current AA sponsorship in the application versus his testimony that he had not had sponsorship since 2019. And lastly, just the years of sobriety matched to his prior years of sobriety. Thank you.
All right, thank you. Excuse me. Well, this court's review is in an appellate posture, not to decide the case in the first instance, but to review whether the Secretary of State's decision is supported by competent evidence on the whole record, or if it was an abuse of discretion or arbitrary capricious. And here, Mr. Amiot has had significant AA involvement, significant counseling, which he completed successfully, more than 7 years of documented abstinence, and graduated from this court's treatment court program, the recovery court program. When did you graduate from that, Mr. Amiot? Do you remember?
2000. I got out of months ago. I believe it was 2019 or 19.
I think it was 19. Yeah, it was soon after I started.
That was right after you came on, sir.
Okay, and so I mean that I think shows a clear record of, you know, he's had more than 7 years of abstinence and engaged in everything that we want somebody to engage in. And the hearing officer went through and found ways to nitpick the substance abuse assessment that weren't really supported by the evidence as a whole. And although relapse history is certainly a relevant grounds to consider, and when there's a period of time where people relapse after the same amount of abstinence, it's you know, that's a relevant factor for the Secretary of State to consider and how long they want to have you abstain. However, it's not like a prior abstinence sets a high watermark. So because the hearing officer seemed to think because you previously had 8.5 years sober, now you have to have 8.5 plus years sober before you'll get a license. I don't think that's the law. It's a relevant factor to consider, but in light of all the other factors that I outlined, I cannot find that the secretary's decision was supported by competent material evidence on the whole record, or that it was within their discretion. So I do find that it's not supported by the evidence, that it is an abuse of discretion and arbitrary capricious. I would grant Mr. Amiot full driving privileges, and you can submit an order to that effect, Mr.
Well, sir, thank you.
Thank you.